Well, good morning, Mr. Chief Justice, and may it please the Court. Today I'm representing an attorney whose courage in challenging the establishment prompted charges that may deter anyone from doing so again. Rather than require clear and convincing evidence of these charges, the lower court improperly sustained them in three ways. First, it insulated the judiciary from criticism in a 54-page opinion that made absolutely no mention of the First Amendment. Second, held Marilyn Pierre guilty of perjury despite factual findings that she lacked deliberation. And finally, by accepting dubious obstruction of justice charges from a prosecutor who herself obstructed discovery. As I hope to demonstrate this morning, a lawyer can criticize a sitting judge without impugning her integrity or qualifications. Marilyn Pierre did neither of those things. She never maligned anyone's qualifications or integrity. In fact, on the campaign trail, she repeatedly emphasized in candidate debates that all candidates were qualified to sit on the bench. But she did criticize the judicial branch of government. She did not believe that the network of judges in Montgomery County were really diverse. She believed that certain judges have in the past discriminated against non-English speakers. She also quoted from a candidate's debate another judge, and although there was really no finding or facts established as to how her, what the lower court calls truncated quote, in any way misrepresented the basic intent of Judge Barry in her comments in a debate, she left out the word as. When it was called to her attention, she corrected it. None of those things singled out any particular judge, impugned any judge's integrity, or questioned any judge's qualifications.
Mr. Kramer, one of the tweets said there are some sitting judges who are only English speakers, send people to jail because they could not speak English, and discriminate against people based on skin color, country of origin, religious backgrounds, or sexual orientations. How does that not get to the... I'm not sure how that fits in not impugning the integrity or of any of the sitting judges.
Where this court has held Rule 8.2a to be violated has been in cases like Attorney Grievance Commission v. Frost, where individual judges are named and where there are particularly volatile accusations. For example, in Frost, one judge, Judge Harrington, was considered to be a lawless judge. Another judge he called a corrupt judge. That's a very different story, and it wasn't in an election context, which this court in Stanilonis indicated requires actual malice. And actual malice, which is embodied in Rule 8.2, will only punish statements that the attorney knows to be false or utters with reckless disregard as to truth. The question is a subjective one. Did the defendant believe it, or in fact, is there clear and convincing evidence that the defendant in fact entertained serious doubts? There isn't any of that evidence here. And this court emphasized in Stanilonis that we shouldn't be dissecting language. Oh my goodness, you left out the word as, for example. Because as Justice McDonald indicated, we expect imprecision, particularly in the course of hotly contested elections. Texts, emails, tweets, online posts, these aren't appellate briefs.
So putting aside for the moment the as and that question, talk to me about send people to jail because they could not speak English. I mean, she acknowledged that there was no evidence that anybody was sent to jail for not speaking English, right?
Well, she acknowledged that in one particular case, no one was sent to jail for not speaking English. I can't prove one way or the other whether someone was incarcerated because they didn't follow a direct... I thought the
evidence before the hearing judge was that there was no... She knew of no support for that.
She knew of no support for that. That's correct.
So that's not parsing language by including or missing an as from something. That's, I mean, how do you explain that? Are you saying that there was a belief that that was true, that there were sitting judges who sent people to jail for not speaking English?
Well, for one thing, no one really probed her subjective belief at the time it was uttered, but also I will point out, even though she, as the candidate, is responsible for the tweets of her campaign, and there's no argument to the contrary there, she managed her Facebook account. She didn't manage the Twitter account, which is where the post came from. There was never a complaint about any post on her Facebook account. So she certainly regretted that particular tweet. And yes, as the candidate, she's responsible for it. But did she have actual malice in uttering it when, in fact, it was apparently a rogue campaign manager that actually did post the tweet? We're not saying she's not responsible for it, but did she violate Rule 8.2a? Did she have actual malice, an evil intent, basically, actually harboring doubts before it was posted? I don't know that she did, and of course when it was called to her attention, she did the right thing in every instance, particularly with respect to the quote of leaving out the word as. She replaced that back. Much more, by the way, than the sitting judge's campaign manager did when it was revealed that the mass email that prompted this investigation in the first place had significant factual misstatements.
What about the statement that she admitted was false, which is that most of the sitting judges have worked at the same law firm, go to the same church, and are related by marriage? If she knows that it's false, it's capable, you're capable of ascertaining whether it's true or not. How is that not reckless disregard?
I don't know that she actually admitted the falsity of that. The record's rather extensive on this point, and the fact is that we presented evidence in the form of a chart which actually showed the interrelationships among the many judges that sit in Montgomery County. And by sitting judges, we're talking a much broader pool of judges than just those who were the incumbents in the election.
But she has the ability to determine whether it's true. Shouldn't we require when people are running for office that they ascertain the truth before they just simply say things that are capable of determining whether they're true or not?
Not if you are applying the New York Times versus Sullivan test to political speech that lies at the core of our First Amendment. That would require not a negligent standard, as Your Honor is suggesting. It may well be that she could have researched it more carefully beforehand. But as Justice McDonald pointed out in Stanilonis, I think it's very important that it be repeated here, we don't parse words. We don't require that you exercise due diligence in the course of a heated campaign. There may be imprecise wording, but fundamentally what she said is probably true. There is an in-group in Montgomery County. And whether you agree or disagree, one can't take that opinion and punish it without violating the First Amendment and the dictates of Stanilonis. It's a subjective test. She certainly believed, and what she was ultimately conveying was that I'm an outsider, like many elections. I'm challenging incumbents. This is the establishment that I'm challenging. And they're pretty cozy with each other. Many of them do emanate from the same law firms. I don't know whether they go to the same church or what have you. Some are indeed related by blood or marriage. And what it really did was offend a campaign manager whose father, uncle, and cousin sat on the Montgomery County Circuit Court. The McAuliffe name is quite well known. The bottom line is there's nothing wrong with being related to another judge, but she's a challenger and she's making the point that we don't have real diversity. Now, if we want to dissect each word or say, well, but you were wrong about going to the same church or what have you, she had heard it. She testified that she had heard that. Was that great evidence if we were to present it in court? I would agree it would not be. It was hearsay. But this is a campaign, a political campaign. We might want to think that judicial elections are different. The First Amendment and the Supreme Court of the United States says otherwise. It's core political speech subject to the highest level of First Amendment protection. So we tolerate imprecision in language. We have to, because this court doesn't want to become the arbiter of campaign rhetoric. And they don't want, I hope you don't want, Bar Counsel to be the fact checker in chief. That's not the function of attorney discipline, but it's also something that, if punished, runs afoul of the First Amendment. What the lower court did, though, was to apply precisely the objective test of negligence to what she said. And she even stated, and this is important at page 27 of the lower court's opinion, that Marilyn Pierre may have a subjective belief that the sitting judges are not really diverse and are part of an in-group, but she nonetheless would punish her for failing to verify or confirm the accuracy. That's not a subjective standard. That's saying even if she did have a subjective belief, we're going to look beyond that, and we are going to hold her accountable nonetheless. She warned other candidates to be certain of the merits of what you say, use appropriate language, avoid petty criticism. Well, we're not here to punish opinions. It may well be that unrestrained and intemperate statements lessen public confidence in the judiciary, but I'll tell you what would lessen it even more, and that is punishing people for criticizing the judiciary. We don't want to deter that. What happened here, though, is the Bar Council took sides in an ongoing election. Because we know that the imprecise language, the misstatements aren't limited to Marilyn Pierre. This was a hotly contested campaign, and the mass email that sparked it contained numerous misstatements, things that the sitting judges also could have verified otherwise and purported to. They said that she tried no civil or contested family law cases in the Circuit Court for Montgomery County. Not true. And that could have been verified easily by judiciary case search.
Are you suggesting that the content in that email blast is a mitigating factor in this case?
What I am suggesting is that Bar Council would punish the challenger and not the incumbent. And this court, or shall I say the other Supreme Court down the road, looks at a public official's motivation in punishing or trying to regulate speech, looks at what the state's intent is. And what we have here as a moral of the story is that if you're the powerful incumbent, you can say what you will and not be fearful of prosecution or deterrence. But woe to the challenger who wants to unseat them. That's the problem. And that's the whole reason why we don't have content restrictions on speech of the kind that Bar Council has tried to impose here and the lower court apparently sustained. The other problem with the court's opinion below is that it finds Marilyn Pierre guilty of perjury and willful misrepresentation without any clear and convincing evidence of corrupt deliberation or a willful plot to deceive. In fact, the opinion itself contains findings to the contrary that show a lack of deliberation, confusion, carelessness. Take, for example, the 1993 student loan case. We've got to go back 30 years to dig up dirt here, but let's look then at the New York bar application. Marilyn Pierre answered the question correctly. She was asked whether she ever failed to answer a ticket, summons, or other legal process served upon her. She said yes. Asked if there was any warrant, subpoena, or further process issued against you as a result of your failure to respond, she answered yes. She reiterated her failure to appear. There's a semantic objection that, oh, she used the word summons and she didn't use the word writ of body attachment. I don't see that as being material. The bottom line is she admitted that she failed to appear as instructed by the court.
Well, isn't a summons something that you voluntarily have to go to the court for? You go on your own steam, so to speak. But a writ of body attachment, you're actually taken into custody and brought to the court. So it's not just semantics. Isn't it isn't there really a sharp distinction between those two things?
There may be a sharp distinction in terms of legality, or if we looked at Black's Law Dictionary or what have you.
Well, in practice, isn't there a sharp distinction?
In practice, but I'm not certain that this young lawyer filling out a handwritten bar application necessarily appreciated the distinction. And what she did was use a term essentially fed to her in the question itself.
It says body attachment.
No, but the
Written
question,
body attachment.
but Your Honor, the questions themselves don't mention the word body attachment. It mentions the word summons in both of those questions. And so she mimicked the question in answering it. I don't think there's clear, that makes clear and convincing evidence.
But does that make it precise enough when you know that there is a writ of body attachment and not a summons, to then ignore the fact that there was quite a distinction legally and in practice as to what actually occurred?
Let's remember that the standard is clear and convincing evidence of a willful intent to lie. And here, she repeatedly disclosed that she failed to appear. She used the term summons. She didn't use the term body attachment. I recognize there is a distinction. Whether that finer distinction was something she appreciated or not, we don't have in the record.
Do you believe the omission of what a writ of body attachment means is not clear and convincing evidence?
Exactly. I do not believe that that's clear and convincing evidence. She used the wrong term. That doesn't matter. That doesn't make clear and convincing evidence of lying, of perjury. Perjury is not something that involves a lack of deliberation. Perjury is a corrupt deliberation. And what ultimately it all comes down to is she failed to appear. That was her infraction, whether she was taken into custody or not. But I'd also express that she's not only a member of the New York Bar, she's a member of the Maryland Bar, she's a member of the D.C. Bar. We don't see any charges that she concealed it from either of those bar examiners. And I will tell you that Maryland and D.C. have far more comprehensive questionnaires for their applicants than the handwritten questionnaire that appears in our exhibits for the New York Bar.
Mr. Kramer.
Yes.
Mr. Kramer, I have a question about notice. Bar Counsel's letter of September 7th to Ms. Pierre did not reference that Ms. Pierre was under investigation for making false statements in her New York Bar application. When did Ms. Pierre receive notice of this aspect of the investigation?
I don't know the answer to that question, Your Honor.
Would she have known this before giving her statement under oath in December?
I don't know.
Also, the letter of September 7th did not include any information that Ms. Pierre was under investigation for having made a false statement about being corporate counsel at Network Engineering. Do you know when Ms. Pierre received notice of that aspect of the investigation?
I think that was after the statement under oath, Your Honor. And I should say that on that point, I don't believe she in any way, shape, or form lied about her being corporate counsel at Network Engineering Incorporated. I don't see any evidence to the contrary.
That leads to my next question. I noticed that in the hearing judge's opinion, the hearing judge mentioned or relied on an analysis that Ms. Pierre did not produce evidence that she had been corporate counsel. Do you think that that involves a shifting of the burden?
Absolutely. It certainly involves a shifting of the burden, because I will tell you, and you can see this from my motion to compel, my second motion to compel Bar Counsel to respond to my discovery, that the president of Network Engineering was on their witness list. They didn't call the president of Network Engineering or any witness to testify otherwise, and what the lower court did was penalize us for failing to prove otherwise. I think we did prove otherwise through Maryland's testimony and also through what few documents remained as evidence that she was performing legal work for Network Engineering. But yes, absolutely a shifting of the burden, and that's clearly erroneous as well.
I have a similar question about the 8.1b violation, where there's a finding of delay in responding to Bar Counsel's inquiries. One of the findings by the hearing judge is that Ms. Pierre didn't produce emails substantiating her contact with insurance carrier. Does that present a similar concern about shifting?
It absolutely does, and candidly, I regret that I didn't produce that. Because the fact is that if you read the petition for disciplinary or remedial action, it suggests, talk about no substantive response having been received. It conceals 16 emails exchanged between my client and Bar Counsel. My client was constantly keeping Bar Counsel informed, and the notion, what's really particularly surprising to me, even offensive to me, is that the lower court considered my client to be lying about the delay in the insurance company denying coverage and denying her insurance defense counsel. Anyone who's ever done any kind of insurance defense work knows they don't make these denials by email. You wait for a letter. That was totally credible, and I'm not trying to contest credibility calls. What I am saying is, clear and convincing evidence? I don't think so. It was a shifting of the burden, and that's a significant problem, particularly amid an opinion that itself, on the judicial applications, for example, belie any notion of intentional misrepresentation.
Mr. Scriven, I just want to point out, you can keep going, but you would be eating into your rebuttal time now.
I recognize that, Your Honor, and thank you. I would just want to make the point, because we haven't hit on it, though I know it's an important point to this court, that the wildly inconsistent guesstimates contained on these judicial applications, and I'll agree, they're a mess. But they're not the kind of mess that would show deliberation. And in fact, when you have a court that says she cannot find Marilyn Pierre to have knowingly and intentionally misrepresented her experience, that the statements on these applications were careless, haphazard, sloppy, inaccurate. She used the wrong form 3 times for an appellate court, when in fact she was applying for trial court positions, numerous typos, even inadvertently skipped items. You don't see on the face of those judicial applications clear and convincing evidence of perjury. What you have is unclear and confusing evidence that belies, in the words of Judge Schaefer, any notion of perjury. Thank you.
Thank you. We'll have about 8 minutes for rebuttal, and we'll turn to Ms. Lawless.
Good morning. May it please the court. Lydia Lawless on behalf of petitioner, along with my co-counsel, Kelly Robier. Marilyn Pierre engaged in a course of misconduct demonstrating a disregard for the truth. At each step of the way, it was to further her personal interests. It was to further her admission to the New York Bar, her judicial aspirations through the Judicial Nominating Commission process, and during the campaign and Bar Counsel's subsequent investigation. This record—
Ms. Lawless.
Yes, Justice Thomas.
Before we get into the merits of the violations, I have a question or two about conflicts that I'd like to ask, and I wanted to get your thoughts on this morning. And one involves a potential broad conflict of interest. Do you believe that the circumstances of this case, with your having docketed the investigation in less than an hour of receiving campaign literature from the sitting judge's campaign, conferring with the sitting judge's campaign chair, gathering evidence, your office being an entity of the judiciary, the commission being an entity of the judiciary, do you think that these circumstances give rise to a conflict of interest, or at least the appearance of a conflict of interest, that the judiciary and its resources are being used to undermine the candidacy of a candidate in a judicial election? And if so, what remedy is there for this respondent, and how can we avoid this in the future?
Your Honor, I don't believe it is an actual conflict of interest or an appearance of a conflict of interest. The case was not docketed within an hour of receiving literature. Maryland Rule 19-711 provides that Bar Counsel should make an inquiry into information that comes to Bar Counsel's attention from any source that alleges misconduct. The information that came to Bar Counsel's attention, if true, would substantiate misconduct. What the record bears.
Let's focus on, Ms. Wallace, I don't mean to interrupt, but let's focus on the source of the information coming from the campaign. Bar Counsel is conducting the investigation in conference with the campaign. You're receiving the information as a member of the Montgomery County Bar Association, and this not being an independent initiated investigation outside of information from a campaign. Could these circumstances give rise to an actual conflict or an appearance of conflict that judiciary resources are being used to intervene in this sitting judge's election campaign?
Your Honor, to answer the question again, no, I do not believe that that's true. As I said, Maryland Rule 19-711 requires an inquiry, and what was done in this case is the information was received, and rather than docket an investigation and immediately request a response from Ms. Pierre, additional information was sought from the source to do my own vetting to ensure that this was worthy of something of an inquiry. The file was not docketed, I think, until the first or second week of September, when Ms. Pierre was put on notice. I don't know if I recall the second piece of your question, but I will note that the Maryland rules provide that there is an option for Bar Counsel to defer inquiries or investigations under certain circumstances, and judicial elections, Your Honor, are not one of those circumstances. The rules are very clear.
But your answer really doesn't respond to the clear issue of the conflict. I appreciate your answer and process that Bar Counsel can initiate an investigation. And actually what Rule 19-711 says is that Bar Counsel should file a complaint. Did you actually file a complaint?
Your Honor, Bar Counsel has never filed a complaint in the history of the Attorney Grievance Commission. We open complaints in the name of Bar Counsel. So, for example, if we receive or read a slip opinion from the Appellate Court of Maryland that contains information that may constitute a violation of the rules of professional conduct, the complaint is docketed in the name of Bar Counsel, but there's no separate document or complaint form that's filled out by Bar Counsel. We would then write to the person. You are aware that that is the language of the rule. That the Rule 1711 does require state Bar Counsel will file a complaint. Yeah, I think that the agency has always interpreted that in the way that it's operated since 1975. There's never been a complaint filed by Bar Counsel in any of the cases where a complaint is initiated in the name of Bar Counsel. What we do is we do the analysis. We either send the underlying documentation we receive, or, as we did in this case, we write up specific questions and request specific information in response to those questions. So in addition to a question about a broad conflict, the use of judiciary resources and potentially intervening or being perceived as intervening in the sitting judge's election, I have a question about professional conflict of interest where you as Bar Counsel are concerned. You received the email as a member of the Montgomery County Bar Association in that capacity. It was not a complaint to your office. How would a reasonable member of the public know whether in initiating this investigation you were acting in your capacity as Bar Counsel or as a member of the Montgomery County Bar Association with an interest in helping the campaign as requested? Your Honor, it's because I was acting in my official capacity as Bar Counsel. All correspondence sent and received were in my official capacity as Bar Counsel. So the answer is basically we would take your word for it? There's no evidence to the contrary, Justice Watts. Mr. Kramer sought in discovery information about my financial... It's not an evidentiary question. It's a reasonable question about the appearance of impropriety and the appearance of a conflict. And when you receive a letter asking for help for the sitting judge's campaign, and you're a member of the Montgomery County Bar Association, and you respond by opening an investigation,
As bar counsel, the question is, how can a reasonable member of the public know or be certain in which capacity you are at, what your interest is?
Your Honor, I don't know what else I can say beyond that I was acting in my official capacity. All information was received by me in my official capacity. There is no evidence that I had any involvement in the sitting judge's campaign. Mr. Kramer sifted through all of my financial disclosures and campaign contributions. Had there been an issue with me investigating or prosecuting this case, I assure the court that Mr. Kramer would have brought it to the circuit court's attention, there would have been a motion that was filed, and there could have been evidence taken. There is no conflict of interest in this case. I was at all times acting in my official capacity in investigating allegations of violations of Rule 8.2 of the Rules of Professional Conduct, which is clearly within the purview of Bar Counsel's mandate.
I have a question. I'm struggling with the First Amendment issues that are in this case.
Yes, Your Honor.
Can I ask you to address Mr. Kramer's arguments on that as applied to the specific tweets and texts that are at issue here, and in particular, the tweet that I think Chief Justice Fader referenced, and I'm concerned about. To me, the 8.2a is facially constitutional, but as applied, I'm concerned about chilling core political speech. So how do you respond to the as applied challenge to the imprecise nature of some of these tweets?
Sure, if I could just run through the tweets. The first is the May 20th, 2020 tweet, where Ms. Pierre said that there are some sitting judges who are only English speakers who send people to jail because they could not speak English. The fact that some sitting judges send people to jail because they do not speak English is a statement of fact. This is not an opinion. This is not whether or not it's diversity. This is not, I believe that some members of the judiciary may be biased or prejudiced or harbor something else that would be undermine their ability to fairly apply the law. These are statements of fact that are false. And I don't believe that either the First Amendment or Rule 8.2 as drafted or has been interpreted by this court in Frost or Stanalonis protect statements that are demonstratively false, where there is no subjective belief that it is true, and there is no objective standard that a reasonable attorney in a judicial campaign would make this type of statement. That's similar for the May 23rd, 2020 statement, where Ms. Pierre was charged not with saying that the judges are somewhat diverse or that the judiciary lacks diversity. She was not charged with stating that the Montgomery County Circuit Court is an in-group. She was charged with stating that the sitting judges, most of them, have worked at the same law firm, go to the same church, and are related by marriage. Those are affirmative statements of fact that are false. And so I think the applied challenge as to those two tweets fits very squarely within what this court has said in Frost and Stanalonis. And in particular with Stanalonis, where the court basically said it fails either an objective test or a subjective test, is the same analysis that the hearing judge did in this case and made findings that it failed either test, regardless of which applies.
With respect to those two statements specifically, my understanding of the record is that they were tweeted out of her account but not made by her. How are we to account for that with the issue of malice?
Yes, Your Honor, and the hearing judge addressed that when she specifically made a finding that Ms. Pierre authorized these tweets. And in support of that finding, she pointed to the record that Ms. Pierre specifically provided this information to her campaign manager, who was charged with managing the Twitter account.
And in what form was the information provided?
Verbally. I believe, yes, verbally. That was Ms. Pierre's testimony at trial.
what was the testimony about the language that was used for that? I mean, was it that the specific wording was given?
I think the findings of the hearing judge were that she relayed the incidents. You know, Ms. Pierre testified that she heard from a member of the bar that all of the sitting judges attend the same church. I think there was testimony that she heard at an investiture that certain circuit court judges may be related by marriage. So that was the information that she relayed to her campaign manager, who was authorized to maintain this Twitter account for the campaign. I would also note that these tweets that went out in May were still published as of August, at least. So if they had, if they really had been false, and if she hadn't authorized them, certainly she could have had them taken down. There was testimony that there were other tweets that she directed that her campaign manager take down that were in fact taken down.
And I'm just not remembering where the falsity of these tweets was called to her attention relative to when they did come down?
Well, we don't know, because the findings are that she authorized the tweets. So whether she knew of them on the 20th or the 23rd, there's no evidence to the contrary. The evidence is that she authorized the tweets. If I could, yes, Your Honor.
There's a question I have, and it relates to the initiation of an investigation during the time of an election.
Yes, Your Honor.
And obviously, from my own background as a U.S. attorney, I'm intimately and have experienced that question of whether to initiate an investigation that becomes public necessarily, through whatever channels, but it always becomes public. So I come from a place where this was a very serious issue, and, taking off from the question of conflict of interest, it's not necessarily as what we consider a conflict of interest, but the timing of the investigation, when it could have been delayed, there's no question that probably there's no requirement that it be delayed, but it could have been delayed until the end of the election, because things were frozen in place by the time the tweets were frozen in place, right? The whatever were frozen in place. So that the public nature of an investigation by Bar Counsel not only could adversely affect the candidate in terms of not only timing, having to deal with an investigation by Bar Counsel, but certainly could affect the view of the public if a person's under inquiry. I don't care what you call it, whether it's inquiry, investigation, or whatever. I'm not parsing that. So how do we take into consideration, or should we take into consideration in any way, the issue of the timing of this investigation?
Your Honor, the investigation was confidential. The public was not privy to this investigation. Under Rule 19.711, the investigations are confidential, and under Rule 19.707, all of the information remains confidential unless and until a petition is filed in this court. So the public was not privy to any of the requests for information at any time during the investigation. They only became privy to it when the petition was filed long after the election was over. I would strongly recommend and encourage that this question be referred to the Rules Committee, and that there be an additional carve-out that specifically says that matters by Bar Counsel can be deferred where there is a pending election. That is not in the rule. So could I treat it separately and put it aside and sort of wait? I suppose I could. The reality of it is the investigation didn't take place until after the election, because Ms. Pierre never responded substantively until December of 2020 after the election was over.
But she was contacted before.
She was.
She was contacted during the pendency.
That's correct.
And we can both agree that grand jury investigations are confidential. in the federal system. But in my experience as U.S. attorney, we didn't initiate grand jury investigations during the pendency of an election because it could adversely affect an election. So I guess the question is, what you're saying to the court is, yes, you can consider this as a public policy, but it doesn't affect the efficacy of what I did here.
That's correct, Your Honor. And I would say further that there is a distinction between grand jury proceedings and bar council investigations, and in particular this investigation, where the only person I contacted for information was Mr. McAuliffe, who is a member of the Maryland Bar and is similarly bound by Rule 19707, the confidentiality rules surrounding bar council investigations. So unlike a grand jury subpoena where you can put a layperson in and tell them it's confidential, you can't stop them from talking about it afterwards. And the record is replete in communications that I had with Mr. McAuliffe reminding him of his confidentiality obligations. So there is that minor distinction that I think did create some more protection generally for bar council investigations, but specifically where information is sought from another member of the Maryland Bar who is bound by these rules.
Mr. McAuliffe was also the chair of the sitting judge's campaign. Do you think that by notifying him of the investigation of his opponent, it gave the campaign information that was beneficial to it going forward?
I have no reason to believe that Mr. McAuliffe violated Rule 19707B of the Maryland rules.
Not that he violated it, but knowing that your opponent is weakened, is under investigation, that you are participating in giving information to bar counsel for the investigation, certainly has the appearance of giving an advantage to the campaign.
Mr. McAuliffe did not know when requests were made to Ms. Pierre for information. This is one of the reasons why complaints are docketed in the name of bar counsel, so that complainants that don't have personal knowledge of the matters that are under investigation do not receive information under our rules that normal complainants, normal witnesses, normal fact witnesses are entitled to as the rules are drafted. Mr. McAuliffe, Your Honor, Mr. McAuliffe never received copies of my communications to Ms. Pierre, and there is no evidence that he knows that she knew that she was under investigation.
That's not the point of the question. When did you provide Mr. McAuliffe of the investigation?
I asked Mr. McAuliffe for information to substantiate the claims, the supporting evidence and documentation to substantiate the claims that were made by the sitting judge's campaign.
And according to the record, that would have been 59 minutes after you received his email to the Montgomery County Bar Association members, correct?
That's correct, Your Honor.
So 59 minutes after his request for assistance, he was aware that your office was investigating his opponent.
I will note, Your Honor, it was during COVID and I was probably working 16 hours a day, and so I wasn't really paying attention to the timing of things. Emails come in, I respond to them. I see something that is relevant, I ask for the supporting documentation, and this is also similar to the timing question because there were allegations of things that people had said, that wouldn't have been documented, that wouldn't have been frozen in time, and to that extent, to the extent that there were memories fade and time passes, there is a reasonable reason to ask for the investigative file, the evidence that supports the allegations that were made by the sitting judges.
I'd ask that everybody in the gallery please be silent and not indicate approval or disapproval of anything that you hear. Ms. Wallace, I do want to have some questions about the findings with respect to the questionnaire, and in particular, for some of the statements in the questionnaire, the judicial questionnaire, there was a finding that the answers were sloppy, that they were incorrect, but it was sloppy. And then for others, not, that there were findings that it was an actual violation. And I'm not sure I really see the path for differentiation there.
Sure.
For example, questions about number of jury trials, it certainly seems to be the case that the answers were wrong, that she had only had 2 jury trials and was indicating 500 proceedings overall and somehow came up with the number 5%. But I don't really see how that would not rise to the level of just being really, really sloppy, like other responses that the court found to be sloppy. Where's the path between those things?
Yes. So this is in response to question 16 on the 8 judicial questionnaires. And so question 16B asks about the percentage of appearances in various courts. And that was found to be sloppy, careless, and the like, inaccurate, not intentionally misleading.
Even though it was really, really inaccurate.
Correct. Question 16C asked for the percentage of litigation that was civil versus criminal. Again, that was found to be inaccurate. That is distinct, I believe, from question 16D, which asks for a specific number of cases you have tried to verdict or judgment. That is very specific language. And Ms. Pierre's testimony was, oh, I read this as the number of cases I handled. And that's the distinction, I think, Your Honor, where it's one thing to say, I'm sort of guesstimating on the number of cases I handled, and I had a lot of cases in this court and a little cases in that court, and maybe it was in the past 5 years, or maybe it was my entire career, versus a specific question about the number of cases you have tried to verdict or judgment, which is very different.
16B was what percentage of your appearances were in the following courts. It's not that's pretty specific. It names the courts. And one was state circuit courts, and the number put down was 55%, and I think the court determined the number should have been 99%.
Correct.
I mean, that's a really specific difference that the court found to be just sloppy.
Right.
I don't see how that's any less specific of a question than tried to verdict.
Because she never claimed that she tried these cases to verdict or judgment. The testimony was she was identifying the number of cases she handled. And what the trial judge said is that it is inconceivable that an attorney with 20 years experience doesn't understand the difference between trying a case to verdict or judgment or handling a case, which is different than guesstimating where you tried those cases or handled those cases. I think they're very different and specific questions. And I think that was the path that the hearing judge made those determinations on, and found that Ms. Pierre's testimony was simply not credible. The question was clear. This was not a guesstimate. She was answering a different question. Similarly, for the number of jury trials she had, she based on her answer that she gave in 16D, and then representing that she had tried over 500 cases to verdict or judgment, and then in the very next question saying 5% of those were jury trials where she knew that she had only tried 2 cases. That's very different than a guesstimate of where your cases were in different courts. And
should we make anything of the fact that Ms. Pierre apparently admits that her counsel admits that these are very inconsistent, very sloppy. How can we say that if the applications are basically a mass, target 1 or 2 questions and say, but you should have answered this one right?
I think that this comes down to the credibility determinations that were made by the hearing court judge, that she offered explanations about why these questions were inconsistent and why she provided the answers that she provided. The hearing judge heard those explanations, found some of them to be meritorious based on the way the question was asked, and then based on other questions like how many cases have you tried to verdict or judgment, to find that it was just sloppy, not to be a credible explanation. And I do think that it is ultimately a credibility determination about her intent and her willfulness, and specifically the hearing judge's finding that she made these misrepresentations to bolster her judicial application. So, you know, whether or not you've tried 55% of your cases in circuit court or 55% of your cases in, you know, the DC Superior Court, I don't know how much that would bolster your application, as opposed to I've tried more than 500 cases to verdict or judgment, and 5% of those have been jury trials. They're you know, sort of for a different purpose, a different intent, a different nuance of the question and the information that is sought. The question of Rule 8.2, and I think that this was borne out in my recommendation that I filed, regardless of whether or not Ms. Pierre's exceptions and regardless of whether or not the court finds that the as-applied analysis is appropriate of Rule 8.2 in this case, does not change the recommendation that is made. And I noted in my filing that I am unaware of a case that involves an attorney who made misrepresentations on numerous judicial applications, and I have analogized that to this court's large body of case law involving applications to the bar. I do want to note for the court in preparing, I think that there are two exceptions that really are due process issues that I should have briefed for the court, but I want to bring them to the court's attention. And that is a finding, and this relates to the New York bar application. On page 41 of the judge's finding, the hearing judge found that where Ms. Pierre signed her New York bar application in March of 1999, she violated the Maryland Rule 8.1b. That's not accurate. That's not charged. What she violated was the New York Rule 101 and the New York Rule 102. Similarly, on page 48, the hearing judge found that Ms. Pierre engaged in perjury when she testified falsely during her statement under oath. That is accurate. She also found that she signed that she violated Rule 8.4b when she signed the New York bar application under oath in violation of the perjury statute, and that is not accurate. Again, the New York rules only apply to the New York bar application. So I just wanted to draw those out for the court, and if there aren't any further questions, I will submit on my papers.
It appears that there are none. Thank you, Ms. Lawless. Just for the benefit of the party, we will take a brief break after this case for the benefit of people who are coming in for the next one. But Mr. Kramer, you have the 8 minutes you reserved for rebuttal.
Thank you, Mr. Chief Justice. I really can't respond to exceptions made by Bar Counsel seconds ago, but I do want to respond to some of the questions that this court has had. Justice Watts, you asked me whether there was any notice prior to the statement under oath of concerns regarding the employment at Network Engineering, Inc. or on the New York bar application, and I see no evidence that there was any notification prior to the statement under oath. To address Justice Booth's question regarding the interrelationships among various judges, Respondent's Exhibit P as in Paul is a chart showing the various interrelationships among the judges. Now, you might say, and I might say, so what? Who cares? Well, maybe some voters care, maybe some voters don't. My client cared. My client believed it, believed that there was indeed these kinds of interrelationships, and that's all that matters for First Amendment analysis as far as I am concerned. Chief Justice Fader asked about the guesstimates on the judicial applications. No one took any exception to the sloppiness with which these applications were completed and read. That's a given. Given that, I think it's antithetical to conclude that, oh, but in this particular instance, that's perjury. I don't have to go beyond the opinion of the lower court to show that those findings, to the contrary, are clearly erroneous. They're internally contradictory. I don't see how you can reconcile the two. As far as my client is concerned, it seems evident that she wasn't representing that she was trying 500 cases to verdict or judgment in a 5-year period. I don't know of any human being who is capable of doing that unless perhaps they work in the state's attorney's office in the district court. You just can't do that. It's obvious she made a mistake and she misread it. Should she have misread it? No. Should she have taken greater care with the applications? Absolutely. She's not charged with incompetence here. She's charged with perjury and willful false statement, deceit, misrepresentation, and that there is no clear and convincing evidence of. In fact, if you look at these applications, what you will find is that after submitting her first one and estimating that she had handled about 500 cases in her career, she then thought, you know what, maybe I overstated that. So the next application you see, Petitioner's Exhibit 8 compared to Exhibit 7, actually reduced that number to about 430. She's guessing. She has to guess, because most of the cases that she handled, you can't simply call up the numbers on Maryland Judiciary Case Search. These are SINA and juvenile cases that are not publicly available. In fact, Bar Counsel, having subpoena power that my client did not before completing these applications, introduced 12,000 pages of docket entries. And these cases are really not cases that fit a paradigm of your breach of contract or tort action where it's settled or it's tried to verdict or judgment. Most of the SINA cases and the juvenile cases, because children are involved and parental rights are involved, do end in a judgment of the court. So there is some difficulty in fitting that to the paradigm. But these cases weren't cases that my client had the ability to simply call up. And in fact, we don't even have good statistics or records of what the disposition was of these cases. It's interesting, the lower court actually considered an updated summary. If you look at the opinion, page 19, footnote 8, the lower court actually considered Petitioner's updated summary that was never introduced at trial. It was introduced as an appendix to the proposed findings of fact and conclusions of law submitted by Bar Counsel. I didn't have any opportunity to object to that. That shouldn't be considered in any way, shape, or form. If that's not clearly erroneous, I don't know what is. When evidence is closed in a trial, I expect the record is sealed, not that it can be supplemented with an updated summary that is taken into account by the lower court when, in fact, none of our statistics or reports, all stipulated to by Bar Counsel as well, were never taken into account. And even though we all worked from the very same docket entries, combing through thousands and thousands of pages, we couldn't even agree to what the right accounting was. Very difficult.
Mr. Kramer, I notice you only have a little under 3 minutes left, and in your 97-page exceptions, I didn't see a recommendation as far as sanction. Assume that we don't uphold all of your exceptions. Do you have a suggestion as far as how the court would handle sanctions here?
I think in handling sanctions, one needs to consider the overall message that you're going to be sending. Because the message you're going to be sending won't simply be to Marilyn Pierre or to deter the infractions you might find. No, the message that you're going to be sending is to deter and to chill speech, to deter people from criticizing the judiciary, to deter people from challenging the establishment, because if you do, then what happens to Marilyn Pierre could happen to you. That's the message that you'll be sending. The headlines aren't going to include the rationale of your opinion, but it's the headline that is the message. And that headline is, you better not challenge the establishment. The incumbents can say what they will, even make misstatements about you, but you better not do so. And, you know, Bar Counsel wants to say that, well, we need to purge.
Can I just interrupt then? Just taking what Justice Booth has asked you, the only way to avoid that is to dismiss this. Isn't that what you're saying? See, I don't understand. I understand.
Well, I think that if you, certainly a suspension, Your Honor, would send exactly that message.
Well, but I'm asking you specifically, are you advocating on behalf of your client that this complaint be dismissed?
Yes, I am. And I am advocating that because If we really want to bring our profession into disrepute, you could do no better than looking at a case where a state official that lacked any exigent circumstances forces herself into an ongoing election, gives the candidate 14 days to respond, accuses her of obstructing justice when she's just trying to get counsel for herself, all right, and now has to scramble for counsel on the eve of the general election that's hotly contested, and that bar counsel knew was there. One point I need to make. Ms. Lawless told you the only person I wrote this down, the only person I contacted for information was Mr. McAuliffe. Let's let the rules apply to both sides. How about it? How about the fact that bar counsel denied any such communications and refused to produce an oral summary in compliance with a rule that she tried to tweak to divest all respondents of their discovery rights? Thank you.